Morning. May it please the court, Nicole Siegel from Burlington and Rockenbach on behalf of the appellant. With me at council table is Jeff Leggio. I'd like to reserve 5 minutes of my time for rebuttal. Last week, this court issued an order asking the parties be prepared to argue why its decision in Northwest Integrative Medicine is not controlling here. I would like to rephrase that and tell you why Northwest is controlling here and the extent of the controlling nature of that holding in this case. In summary, and quite just succinctly, it is directly and 100% controlling as to what we have addressed as sub-issue A in this appeal. That is the issue that was raised by the State Farm as the same defendant in each case. They raised the same basis for motion to dismiss in each case. And
let me ask you this:
yes.
I'm not clear. In Northwest, it was important that the allegation was that although there were two methods of determining a bill, that State Farm always used the Medicare list method. I mean, is that allegation the same here?
It wasn't phrased the same, but it was, they have elected to use this method. I don't think we use the word exclusive, but we say they have elected to use this method, and they did not, the policy, it's obviously the same policy, and they did not, and they admit, obviously, elect that method, the Medicare fee schedule method.
Well, go ahead, Judge.
There was a provider in Northwest Center versus State Farm. The case was brought by a provider who said that it was unfair to me because I didn't know blah blah blah. Here the case is not brought by a provider but by an individual, and it seems to me that that's significant. But do you think that difference is significant? If so, or if not, why?
It's not significant at this stage. I think as soon as we get back here on remand, which we'll hopefully do here, the cases are going to diverge because we've actually, what the relief requested and the declaratory relief requested is different from each side. They both have different interests, the providers versus the insureds here. As of this stage, though, we're in the exact same position. We've alleged, as the plaintiffs in Northwest did, that the policy does not allow them, or they did not elect the Medicare fee schedule method, that they have in fact utilized that as their method of determining fees, and that is a violation of the law. That is what the trial court in both cases decided. There's no controversy here. Because they didn't elect it, they can't use it, which is a little bit of a strange argument, but it was the same exact argument made by them in both cases, and it was the same exact holding by each trial court. The trial court here actually cited and relied upon the decision in Northwest. And I also would like to just point out that here State Farm filed a motion for stay earlier where they said in their motion they wanted to stay our case pending resolution of that case, and they said the issue before this court in both appeals is the same. Obviously, we can't tell what's going to be controlling until an opinion is issued, but at this stage, the allegations are the same. We both made proper allegations in our complaint that would have allowed us to go further.
One other difference, and this is really what concerns me, is also is that in this case, the relief that you're seeking, I mean, it seems to me that if you were entitled to relief, people would be entitled to, because your client had to pay extra to the provider, in this case, that your client would be able to, or a client would be able to recover the difference between what they paid and the reasonable fee, if a reasonable fee had been charged. And so the problem here is this trial judge also ruled on that this was not appropriate for class treatment. And in your case, the problem I see is that we've got, if it's appropriate to determine the big question whether State Farm in fact always used the Medicare method of determining it. Once we get beyond that, the case is not. I'm concerned that the case is not appropriate for class treatment, and that we would have to affirm that aspect of the judge's decision, because each individual service that's performed, in one case might be an MRI, one case it might be a chiropractor. Another case, it might be, a different type of medical provider. Will need to be a trial as to what a reasonable fee is on each of those figures, and then what the person would recover. So it seems like at that point, this case is wholly inappropriate for class treatment, assuming that it's appropriate for the first part. And that's the thing. We didn't reach that.
Correct.
Northwest, but in this case, it appears that we could reach that because of the different posture and affirm
Your
on
Honor,
that message.
oh, I didn't mean to interrupt.
Yeah, I just want you to answer that, because that's really what I'm
Yes,
concerned about.
that is not our claim here. Our claim, we are not alleging that we want to go back, and that's going to be a difference when we go back to a trial court and what we're asking for, because we're not asking, the providers are asking to go back and have a determination made as to reasonableness and to get a reasonable fee, because they don't ever want the Medicare fee schedule. We don't care if they use the Medicare fee schedule. We just didn't want to be billed the balance, which would have been prohibited if State Farm had properly elected the Medicare fee schedule method. So in our declaration, and what we're asking here for as part of the declaration, is the difference not between what a reasonable amount would have been and what we paid. We're asking for what we paid to the provider, which is the difference between the amount paid and the amount billed. That's what, it's not a reason, there's not going to be any determination as to reasonableness at this point.
How would you even be entitled to that? In other words, like, if you were right, if you're right as to what happened, and in some cases, it seems to me a Medicare fee schedule might be fair and reasonable. But how would you even be entitled to everything when all you would have, if they'd have done the right thing according to you, all you'd be entitled to is the difference between a reasonable fee and what your client was billed?
Because those are the damages that we've suffered now. We've actually paid this money. We have had to pay this to the providers. That's the damages we suffered as a result of their improper election. So that's how we can justify asking for that and going back and just not asking for the reasonable amount, because we haven't been asked to pay the difference between the reasonable amount and the bill. We've been asked by and paid by the providers. We paid to the providers the difference between the billed amount and what they reimbursed based on the Medicare fee schedule. So that's the damages that the plaintiffs have suffered, and actually suffered in this case and have paid, and that's part of the class, is that they've actually paid these balance bills.
What if it turns out after you have a full trial that for this chiropractic service, the Medicare fee schedule is a reasonable amount?
That's part of what we've argued here, is that they've utilized this Medicare fee schedule, and now they don't get to argue the reasonableness anymore, because we're out this money to the providers.
What if it is a reasonable amount? What if you have a trial on that issue, and for that service that was absolutely reasonable in that time and place and community?
First of all, I do want to point out that I don't even think we're there yet as far as where we are and what the trial court dismissed our complaint on. I think it's the same as what happened in Northwest, and we're at the same stage. The same thing could happen in Northwest. The providers have asked to go back and determine reasonableness, and it could be the same thing as to, it's the same issue. So I want to make that point clear, that would not prohibit reversal of a dismissal here, because it's.
But in Northwest, the judge didn't rule on the appropriateness of class treatment.
Correct.
Your judge did, did she not?
The judge did rule on the appropriateness of the class and said that this would end up being a bunch of individual issues as to reasonableness. And again, that's not what we're asking for here. We have suffered these other damages, which are set. We could provide the bills, what was sent to us, and a check of what was paid, and a receipt, and that's all. There's not going to be medical testimony. There's no, testimony of people talking about what's a reasonable fee in the community. There won't need to be anything along those lines. This is going to be very straightforward. It would have to be independent, obviously, but that doesn't prohibit class action complaints just because the damages may end up being individual. And we cite to case law in the briefs, but there's, plethora, of cases that say that just because damages may be individualized, that it means, there can't be a class action. Liability here, and what we've argued, is the same, is going to be universal as to every single class member, and a determination by a court as to whether or not State Farm is in fact, or has in fact, utilized the Medicare fee schedule, even though it didn't elect it in its policy, which is a violation of virtual imaging. It's going to be universal as to all of the class plaintiffs. And then,
But you
based
dis-
on
you
what
dis-
we are asking
You
for,
dispute, though, that assuming that you prove that, I mean, I get that that's
Mm-hmm.
an issue. You're saying that there's nothing else that needs to be done, that you're entitled to recover the full amount, even if the fee schedule amount is actually a reasonable amount to charge under the other method.
that is a claim that we're bringing. And
Okay.
at this stage, we haven't had the opportunity to see whether that's going to, that's what we're alleging. And that's a distinction between the providers and the insureds here in the claims, and why they're going to diverge once we get out of this court and hopefully go back to the trial court. But right now, at this stage, we stated a case. Class relief is proper because, if it's the same issue. It's the same basic issue that would be determined as to all the class members.
I've got a couple of questions if I
Okay.
could. You keep using the term elected, and
Yes.
I'm concerned about the use of that word because clearly when they issued the policy and they came up with the policy language, they elected one method.
Yes.
And as I understand it, you're arguing, but in practice, you elected to do it a different way. So it really kind of sounds like you're using an estoppel argument that, because in practice you're saying one thing, but in practice you're doing something else. You're trying to kind of hoist them on their own petard and now say, you're stopped. You basically elected something even though you didn't do it in writing, and we shouldn't have to be suffering these balance bills, as I understand it. Not sure that I really read your complaint to be proffering a estoppel theory, but it kind of sounds like that's what you're going on. Because the other problem that I've got is you have a contract. And the contract outlines their responsibilities and your rights. So if, in fact, in practice, they haven't been following what the contract says they're supposed to, you're entitled to enforce the contract and make them do it right. I don't think that that's going to morph into, I don't understand how contractually that's going to morph into, we should not be balanced bill. It might be that they're going to have to go back and do a recalculation, and they're going to have to go back and pay the providers more or reimburse you what they should have paid the providers, I guess makes sense. But it's not like you're going to be totally off the hook, because by contract, by taking this policy, you agreed that you would be responsible for the balance bill after a reasonable amount was paid. That's one problem that I have.
Sort of was the
If I
same thing.
could-
We both have the same problem, although in different words.
But I also, let me ask this. If I understand it correctly, under the PIP statute, one of the benefits of the fee schedule method for the insured is you're not responsible for any balance billing. The statute confers that benefit. You're trying to now say we shouldn't have been balanced billed. So I'm struggling with this concept of we're not suing for a benefit, because you are. You're suing for a statutory benefit, no balance billing, and if that's the case, why aren't you responsible for the pre-suit notice?
PIP benefits, I get how you're describing as a benefit in the give and take of, everybody has a benefit here, the insurer, only pays a limited amount. PIP benefits are defined in the statute as medical benefits, death benefits, disability benefits. It's a defined term, benefits in the statute under subsection 1. For medical benefits, it's 80% of the reasonable medically necessary fee. That's a whole separate issue. As far as medical benefits and PIP benefits as it's used in the statute, which requires, the statute that requires the PIP demand letter, excuse me. So that is referring to benefits as it is defined in the statute, which is these medical benefits, and that's not what we're seeking here. I get how you're using the term benefits of we're getting something out of this, election or, the insurers.
The
choice to-
protection of no balance billing. That if this method is used, I don't pay anything. Why is that not a benefit under the PIP statute?
I mean, it's a benefit to the insureds, but it's not a benefit as that is defined as a PIP benefit. I mean, that is a defined term in the statute. There are medical benefits, disability benefits, death benefits. All of that is defined in the statute.
But the pre-suit notice statute is basically designed to say, you insurance company didn't pay what you were supposed to. And it strikes me that when you're, in essence, saying that by way of, I got balanced billed for something I shouldn't have, it strikes me you're suing for a benefit. And I'm still not understanding why the pre-suit notice provision doesn't apply.
I mean, all I can say is I don't believe it. And under the statute, a benefit is a defined term, and this is not a benefit of. There is a separate statute requiring that if the insurer elects the Medicare fee schedule method, that they cannot balance bill. And so we are seeking, the damages that was result in their failure to properly elect that section, which our insurers would have been entitled to. Insureds wouldn't have been able to be balance billed. And because State Farm did not properly elect a method, we had to pay this. We're out this money now. We're already out it. It's gone. It's out of our pockets. We've had to pay it as a result of their failure to properly elect the method. And as far as just the specific, I mean, I get that it's a benefit, in the grand scheme, but it is not a benefit as it is defined. It's not a PIP benefit as defined in the statute, which is what the pre-suit demand letter, references benefits as used in this statute, which is subsection 1 and talks about the different, benefits, death benefits, medical benefits, and disability benefits. I am way over time, so I would hope that if I could get an extra minute or so to
Can I
rebuttal.
just ask one more question? Just a second, too much?
Absolutely.
But see, it seems here like that they under the case law, which I'm pretty familiar with, this one went up, they did not elect the Medicare method. I mean, that's
correct.
okay. But so what you're saying is that
Well, they did not, in their policy, they did not notify us.
They
I'm
did not
sorry, they did not notify us of their
you.
election.
Yeah. They did not notify you
Correct.
sufficiently of the decision to use the Medicare method. So they used the other method. And so what you're saying is that they weren't honest about it because in effect, all they did was apply the Medicare schedule.
Yes.
Okay.
And we were stuck, without the benefit of that no balance billing.
But under that policy, under that state of affairs, your clients still would have owed something. They just, because, they didn't elect the Medicare schedule under the contract.
Correct, and so if they'd actually done that, but that's not what they did. They didn't use that method, and so we're out of pocket this money that we had to pay to our provider. So that's, if they had used that method and we were balance billed, there would be nothing we could say, but they didn't. They used this method, they paid a lower amount, arguably. Everybody agrees that the Medicare fee schedule method is the lowest amount, which means we actually paid our providers a higher amount than we would have had to pay. So that's all for now, and I'll hopefully get an extra minute. Thank you.
Good afternoon, Your Honors. Marcy Aldrich for State Farm, along with Nancy Copperthwaite. I am also here to first address the order that the court issued to discuss the effect of the Northwest Center for Integrative Medicine case on this case. As the court has already realized, it is significantly not controlling on one specific request, which is that obviously the trial court in this case dismissed on a variety of additional grounds that were never reached by this court in Northwest or the trial court in Northwest. In particular, the class action ground, which is front and center here, as well as the demand letter ground. So let's talk about that. Counsel said the demand letter requirement should not apply, but the purpose of the demand letter is pretty clear, and as this court found in the MRI Associates of America case, the statutory requirements surrounding a demand letter are significant substantive preconditions to bringing a cause of action for PIP benefits. And in some of the other cases that we have cited in the papers, there has been a clear recognition that the purpose of it is to try to avoid litigation. So the doublespeak and the attempts to try to work around that sort of fly in the face of the statutory purpose, which is to try to avoid litigation and give an insurer an opportunity to cure many of these violations, which, if not brought in a class action, are county court disputes. In this case, State Farm was not afforded that opportunity. Neither the nominal plaintiff or any member of the putative class has been alleged to have served the company with a demand letter. Counsel tries to say, oh, well, benefits are limited to just these statutorily defined benefits. And there's no question that the statute does define certain benefits. It says medical benefits and death benefits, but there's no indication that that is an exclusive definition or limitation. And clearly, any of the benefits that the statute might bestow, including but not limited to the issue about balanced billing, is something that should be covered by a demand letter.
So your position would be that the class representative and each individual plaintiff, in order to preserve a claim, should have sent a demand letter saying, hey, you promised to charge a reasonable amount. You use the Medicare fee schedule, which is not reasonable. I think I'm owed X dollars as a result, right?
That is this court's ruling in...
Is that what you're arguing here?
Yes, it is, Your Honor. And indeed, in the Bristol West case by this court, Judge Warner noted that bringing a class action would probably be a practical impossibility under the PIP statute because of that requirement. So my position in that is consistent with Judge Warner's observation in that case. Additionally, there is this class action issue that the trial court, neither this court nor the trial court got to in the Northwest case, and it is front and center here. The law is very clear. In the virtual imaging case out of Supreme Court and the more recent orthopedic specialist case that had not come out at the time that we argued the Northwest case, both of those are very clear that the decision about the selection of the methodology to pay and to limit reimbursement based on the schedule, that election must be made in the policy, not in some subsequent actions, not in an explanation of review, but in the policy. And moreover, the virtual imaging court is very, very clear that the decision about
So what is the remedy if the insurance company and the policy says we're going to use this method, but in practice they're actually using the alternative method? What remedy does the insured have for that behavior by the insurance company?
It will depend on the method, obviously. So assume there are two methods.
There's two methods.
Yes, there's two.
Policy says we're going to use method A,
Yeah.
but in practice they're actually using method B.
Okay, so, and here that would be, because this is established by Northwest, State Farm, and State Farm doesn't contest this, State Farm elected the fact-dependent reasonableness methodology. It did not elect to reimburse based on the schedule of maximum charges. In here, we don't have those charges to know whether we actually paid on the fee schedule or not. But assuming that the fee schedule was applied, notwithstanding the fact that the policy says that State Farm would pay reasonable, then the recourse is for the insured to say, or for the provider. And in fact, this is another key difference. That's exactly what the providers did in Northwest. They said, your policy didn't elect the fee schedule. Your policy elected reasonable. Therefore, you don't get to limit it based on that schedule. And we want more money because we think more money is reasonable. So you asked what the remedy is.
But you're saying only the provider has that remedy. You're saying the insured doesn't have that remedy?
Well,
Can't do anything about that situation?
The insured can also have that same argument. We have, or to sort of give an example, let's say the provider sends a charge for $200 to State Farm and to the insured, because the insured pays, how PIP works is State Farm pays 80% of whatever it is, and the insured pays 20% as their copay. So the provider sends a bill for $200, and then of course the provider's position is $200 is the reasonable amount. My billed amount is the reasonable amount. State Farm says, we don't think that's reasonable. We think $100 is reasonable, and we're going to base that on the scheduled maximum charges. Therefore, we're going to pay $80, and our insured, because our insured is only arguably obligated to pay their own providers 20%, should also pay $20. But that's between our insured and the provider. We can't enforce that. We pay 80% based on what our contract requires, which is that we pay a reasonable amount. And the issue of how much the co-payment must be or amounts in excess of that is an issue between our insured and that provider. We would
Okay,
hope.
So let me ask, does the reasonable fee method require some kind of calculation?
The reasonable fee method, as written into the statute and in our policy, requires and allows the parties to consider a multitude of circumstances to determine
But if
the
you're considering a
reasonableness.
multitude of things, aren't you doing some kind of a calculation? You're making comparisons or whatever? Yes?
Absolutely.
Okay. Then it's something over and above just taking a number and multiplying it by 0.8 to get the 80% amount, right?
It may be, unless if we took a look at the
If that's
face
the-
amount of the bill and we said, we think $200 is reasonable, then we would.
If it's the case that there's some kind of comparison, there's some kind of calculation or whatever, how could it ever be appropriate under the reasonable fee method selected by the policy to use a single fee payment schedule like Medicare?
The position
Because
is,
there's no calculation there. There's no comparison. It's just one thing you're looking at, and then you take that number from the one thing you look at, multiply it by 0.8, and that's the amount you pay. How can using just solely the fee schedule, how could that ever comply with the reasonable fee method?
the Supreme Court was clear that it might.
They said that you can consider it, so again, if you're looking at an array of things, it certainly seems reasonable that one of the things you can look at is the Medicare fee schedule. But I don't think the Supreme Court ever said, and there's no case that has said it yet, that it's okay if the insurance company wants to only look at one schedule.
Well, the issue of the comparison, I would submit that there's not necessarily a comparison that is required, but what the Supreme Court said, and I quote,
Well, then what is the reasonable fee method then if it's supposed to, and doesn't the statute have some language about, the community fee schedules and all those, doesn't it by itself kind of connote there's some kind of a comparison calculation or whatever?
it has a variety of sources that an insurer can consult. It does not mandate that it consults all of those or one of those.
But again, it's doing something more than looking at one schedule, isn't it?
Arguably not, because the ultimate issue is whether what you pay is reasonable. So if we were to use one factor, so let's just
Well, how do
say
you know if what's reasonable if you're not comparing anything?
it would be up to a jury to determine whether the payment was ultimately
No,
reasonable.
it's the insurance company's responsibility by contract to come up with a reasonable amount. It's not something that you leave to a jury. The insurance company, so how do you figure out what's reasonable if you only look at one thing?
The one thing may be reasonable if you go through the analysis. What the company did is looked at a schedule, and the statute says in the factors that a reasonableness insurer can consider, it says that you may consider state and federal fee schedules applicable to auto insurance, and it looked at a state schedule, which was the schedule of maximum charges in the PIP statute, which in turn referenced Medicare pricing, and it applied that as what it believed to be the reasonable amount. Now, the ultimate question is, was that correct? Was the amount paid actually reasonable or not? And what the Supreme Court said, we do not conclude that payment under 5A2, which is a schedule, could never satisfy the PIP's basic reasonable coverage mandate. So they did not foreclose that a fee schedule payment could not be reasonable. Now, the question is, did State Farm do it routinely? But even if it did, if it hit the mark, if they paid reasonable on some occasions, then the question is that you have to go through this fact finding, and in fact the Supreme Court said in virtual imaging that the issue of reasonableness is a fact-intensive individual analysis, and whether and it goes both ways. It's not just what State Farm paid, it's what the provider says is reasonable. Because what we have going on with Northwest in this case is the two cases are internally inconsistent. Because on one side, we have Northwest with providers saying, I billed you $200. You should have paid me $160, which is 80% of $200. And therefore, I billed the insured $40. And we've got here, in this case, we've got an insured saying, the provider billed me $200. You should have only paid them $80 based on the fee schedule, and I should have only been paid $20. Those two can't go together. They're internally inconsistent. The two cases are at loggerheads with each other. The question is whether if we don't elect the fee schedule, and we don't dispute we did not elect the fee schedule, So then the question becomes, we elected the reasonableness method in our policy. Did we live up to that obligation? And we have to determine that bill by bill, case by case, what, if we paid the fee schedule or whether we had paid on a particular bill on a different amount other than the fee schedule.
Why isn't that issue, in other words, like in Northwest, that issue, you know, what you did as a whole, what policy you implemented, why isn't that subject to class treatment as it was in Northwest?
Well, for
That, you know, I mean, that would be a global view, like Engel, you know, like in the fraud and in an Engel case. You know, each individual shouldn't have to go prove that. They should be able to rely on a class finding that in fact State Farm, if they can prove it, didn't use a reasonableness method, that they always used the default method, for example. And then it might take individual cases to go ahead and sort of figure out to sort what was going on.
Well, a couple different reasons, Your Honor. Number one, at the end of the day, it comes down to whether we met our contract obligation to pay reasonable. That's individually based. But more importantly, they didn't ask for that here. In Northwest, another significant difference is they disclaimed. There was an active disclaimer of any claims for monetary relief, supplemental or otherwise. Not so in this case. They've admitted that they are seeking damages. And that is not susceptible. It requires the demand letter to be done individually. But more importantly, what is significant is that was the provider, that was one method. But here, we are talking about they want to recover reimbursements, that bills that they have been billed by medical providers that we don't have access to. Those are co-payments. Those are balance bills. Those are not things we have control over, we can argue over. That's a relationship purely between the insured and these providers. We don't know what they got billed. They have an ability to contest those on their own, either based on reasonableness or any other method. They're essentially asking us to walk outside of our contract and litigate an issue that is outside of it.
Yeah, but again, I'm not really understanding, because I understand that it's, you know, that one, let's say, for example, that, you know, they're able to prove that, you know, y'all didn't do what you should have done. You didn't use a reasonableness method. Okay, and that's the finding, you know, that a jury makes. I mean, once that happens, it seems to me that the reason it's not appropriate for class treatment after that point in time is then in each case you have to go back and figure out what a reasonable amount would have been, and then their liability would have been for the, you know, what you paid in the reasonable, how that would have impacted what they would have paid. Wouldn't have been the whole amount they paid.
Well,
but it would have been something, and each case is going to necessarily be different.
all right, but the problem.
But the first part seems to me exactly or close enough to Northwest, unless you're saying that they didn't ask for that. If you say they didn't ask for what the plaintiff did in Northwest, you know, that's a totally different.
They have asked for supplemental relief for reimbursement of all of these amounts, and that would be something that the trial court would have to consider. But also, what's really important here is they have admitted, we have admitted, this court has established that we did not, in our policy, elect the fee schedule. And if that's true, they do not get the benefit of 5A5, which is that balanced billing limitation. Right. So they cannot state a claim, and you know, facts and the factual issues in Northwest don't apply. Because it's very simple. The only way you get to avail yourself of that provision is if the insurer has elected the fee schedule in its policy, and it is uncontested that State Farm did not. Therefore, I would ask that that this court affirm the trial court ruling. Thank you very much.
Let's give you a minute here if you would to.
Thank you. I appreciate the extra time here. A couple of points as to the class action. Judge Gross, I think you hit the nail on the head with regards to citing Ingle. It is well established that if there's a common liability issue, that damages can be established, or you know, there are methods to deal with damages aside from just not certifying a class at all when you have one common issue as to liability. This court's decision in Freedom versus Wallet, which is cited in our briefs, several other cases cited in our briefs make it clear that the presence of individualized damages does not prevent class certification. As to some of the other points made, I want to make clear again, we are not challenging the amount that they paid to the providers. They had that right to make that choice, and we allege that they did make that choice, and now we want the damages, the actual damages that the plaintiff suffered as a result. Ms. Aldrich mentioned that the providers that we're essentially asking for the same thing as the providers in that they asked to go back and have a determination based on reasonableness. But that's not what we're asking for here, because that's not the damages we suffered. The providers suffered the damages of not getting that difference between the Medicare fee schedule and what is a reasonable amount. The damages that we have actually suffered are the damages that we had to pay to the providers, which is the difference between the amount billed and the amount paid under the Medicare fee schedule. So I want to make that clear, that we are not seeking any determination as to reasonableness. We're not challenging the amount that they paid. They had that right to determine that that was a reasonable amount, but because they messed up, essentially is what we're arguing, in making their election, we've suffered these other damages. So we'd ask that the court reverse and remand this for the trial court to get into some of these issues that have been raised, to let it all, see how it all shakes out. Thank you.
Okay, thanks, folks. Thank you. We'll recess.